Hello viewers, students. This is Dr. Kashinath Neharkar, Assistant Professor Sri Shivaji Law College, Barbhani, and I welcome you in my YouTube channel Law Education Volunteer Dr. Kashinath Neharkar. Friends, in this lecture we are going to discuss the concept of transferability of property. It means what property can be transferred under section 6 of Transfer of Property Act. So friends, before that, do not forget to subscribe this channel and please press bell icon to receive further notifications. So friends, let's start with today's topic. Friends, in last lecture we have discussed what is the concept of transfer of property, and where we have discussed that transfer of property is nothing but the transaction between two living persons for the transfer of property. It means this is the transaction to transfer property from one person to another person. So by that transaction, interest in a property can be transferred from transferor to transferee, because the parties to that transaction are called as a transferor and transferee. So the transferor transfers his interest in the property, and that interest goes to transferee, who is second party to that transaction. So that mode may be, the mode of transfer may be sale, that can be a mortgage, or that can be a lease. There are different modes which are provided by Transfer of Property Act, which provides for the transfer of property. So one of the essential of valid transfer of property is that that property must be transferable. Friends, in last lecture we have discussed there are certain essentials of valid transfer of property under section 5, and as you know, section 5 of the act works as a touchstone to decide the validity of any transaction as per the provisions of Transfer of Property Act. And there are some essentials of valid transfer under section 5, and one essential is that property must be transferable. It means it should not be disqualified from the transfer. So in this lecture we are going to discuss the transferability of property, what properties can be transferred and what properties cannot be transferred. So see, section 6 of the act deals with the transferability of property. Section 6 of the act deals with the transferability of property, and according to this section 6 of the act provides two things. One is, firstly, it provides general rule, and that general rule is that all kind of properties are transferable. Say, according to section 6, the general rule is provided, and this general rule is the property of any kind may be transferred. It means there is no general prohibition of transfer of property. As well as apart from this general rule, section 6 provides exception to this general rule also. It means those properties which are mentioned to or in section of in explanation of section 6, such properties cannot be transferred. So what cannot be transferred, we can say, so that exception provides what properties cannot be transferred. So firstly, what cannot be transferred under section 6, the non-transferable properties have been divided into two categories, because now it is not necessary to see which are those properties that can be transferred. Now we must see what are those exceptional properties that cannot be transferred. So more importantly, we must see the exception to the general rule, which will help us to understand what are those properties which cannot be transferred. So these non-transferable properties under section 6 are divided into two categories. The first categories of properties are those properties which are made non-transferable due to the other provisions, due to the provisions in other laws for time being in force in India. There are certain laws, afterwards we are going to discuss. And secondly, those properties which are made non-transferable by virtue of section 6 of Transfer of Property Act itself. So let me firstly see which are those non-transferable properties by provisions of other laws for time being in force in India. So firstly, these are there are certain laws like personal laws are there, civil procedure code is there. So there are certain laws which makes some properties non-transferable. Let me see. In Hindu laws, this is also the personal law of Hindu. So in Hindu law, corpusculary property is regarded as non-transferable, and it works as a restriction on a transfer of property. It means the corpusculary property cannot be transferred. When such property is subject matter of corpusculary, it cannot be transferred. And similarly in Muslim law, in Muslim law there is nothing like the corpusculary property etc. But in Muslim law, the property of Waqf and the office of Mutawli, these are two properties that cannot be transferred. So such properties are non-transferable due to the provisions of Muslim personal law as well as due to the provisions of Hindu law. Now we must see certain provisions under Civil Procedure Code also. Specifically section 60 of Civil Procedure Code prohibits the attachment of necessary cooking vessels and tools of artisans. So such properties cannot be attached by the operation of any decree of courts etc. So even the decision of court in insolvency cases that cannot operate to attach the properties of artisans, like the tools of artisans or the cooking vessels of persons. So such properties cannot be transferred. Then there is another law that prohibits the transfer of some interests or property, and that is the compensation which is provided by Act of 1923, that is Workman Compensation Act 1923. So the compensation which is received by the workman or the dependents of workmen as per the provisions of Employees Compensation Act or the Workman Compensation Act 1923, this cannot be attached at any cost. Even decree of court also cannot attach this. So these are some properties that are non-transferable due to the provisions under other laws for time being in force in India. So now we are going to discuss the second categories of properties that cannot be transferred. So these are provided specifically by section 6 of that act, and accordingly, see, the first kind of property that is non-transferable is spes-successionis. Spes-successionis, see, these are the properties under the succession. These are the properties that a person can get in a succession, or these are the properties under expectation. So such properties are not property of in a present. That person is not the owner of that property in a present, or that presently that person have no vested interest over that property. Therefore such property is not transferable, because it is just possibility of getting property in a future through the succession. So possibilities, these are the naked possibilities. Rights, it is not the right. So how the possibility can be transferred? Second is mere right to re-entry. So mere right to re-entry is nothing but right to resume the possession of land. For example, in a lease transaction, when a person enters into lease transaction, he gives his land, his property on a lease, and if the terms and conditions of lease are violated by lessee, in such circumstances the lessor has a right to resume the possession, to get back the possession of property. So this is called as a mere right to re-entry, and it cannot be transferred. So you can transfer right of re-entry along with the property. and this is special right available to lease only, available to that person only who is owner of that property, so he cannot require other person to get the possession in his absence. Then third property is easement apart from the dominant heritage. See, we know, we have studied the concept of servient heritage, dominant heritage, and the servient heritage means that property on which the owner of dominant heritage have a right to exercise for beneficial purpose. So the easement right? These are the incidental rights available to owner of dominant heritage. Therefore, you cannot transfer the easement right without transfer of dominant heritage. So, if, for example, if right of way is available to particular person, and that right of way is on neighbor's land, so that person cannot sell his right of way to third person without transferring his property. So this is incidental right, so it cannot be transferred because it is incidental right. The next property is restricted interest. So those interests which are specifically reserved for the personal enjoyment, and these interests are available to that person because of special qualities, capability, or whatever the reason why. So when such interests are available as a personal enjoyments, for example, movie tickets that are purchased by you cannot transfer it. Even bus ticket you cannot transfer other person. Once you purchase, it is your benefit, you cannot sell it to third person. So even the office of trust, because these are granted to particular person only, though, so there for it works as a personal interest, it is available there to that person as a personal enjoyment, so it cannot be transferred. Then next property, that is non-transferable right to future maintenance. See, again, this is a personal benefit when a person receives the maintenance for future of life. So again, this is available to that person. This is the restricted personal interest, it is available to that person only. So even areas of maintenance can be, but the personal right to receive the maintenance, it is a personal right, so it cannot be transferred. For example, A and B, these are the husband and wife. So B is wife, and after a few years the dispute occurs between them, and they went to family courts, and family court granted maintenance to wife from A. So she is entitled to get the maintenance to meet with the expenses which are necessary for livelihood, whatever the things. So she can get the maintenance from husband, but this right is available to her, she cannot transfer it to third person. So this is also the property that cannot be transferred. So next property that cannot be transferred is mere right to sue. See, mere right to sue, again, these are the naked rights, naked interests, which are not in a specific form, because these are just mere possibilities that person may get success in such suit or not. So such suit cannot be transferred, such a right to file suit cannot be transferred. So suit for the damages in a tort, for unliquidated damages, such cannot be transferred. So the person can transfer the right to suit, right to file suit for recovery of specific amount of money which is due under contract, etc. But in torts, where what the amount of compensation that to be received, that is dependent upon whether that person succeeds in a suit, and what shall be the amount of compensation that will be decided by judges itself. So that is the reason why the person cannot transfer mere right to file the suit. Then next property which is non-transferable is public offices. Public offices, see, This is necessary. This property is made non-transferable to protect the dignity, to maintain the dignity of property, because such persons hold the property. Such persons, those persons who holds the property of having particular qualification, experience, etc., they have some special capabilities. That is the reason why they have been appointed there as officer through competitive examination, etc., whatever the process is. And so it is necessary to maintain the dignity of that post, dignity of that salary. So such properties cannot be transferred, else the people will sell the posts like collector, district magistrate, judges, etc., whatever it is. So that may happen. That is the reason why this property is also non-transferable. Then the pensions, public, again it is a public policy. Pensions cannot be transferred. Again, pensions are available to persons for their livelihood. It is personal right. So that is payable to only that person who are entitled to get it. So how right to receive the pension can be transferred to that person, other person. So this is again the public policy, and such pensions cannot be transferred. So you can see even in a banks nowadays, it is compulsory to bring the pensioner to get his salary from bank accounts also. So this is just an example. Then next property that is non-transferable is transfer for unlawful consideration, unlawful objects. So such a properties are again non-transferable. So friends, this is how we have discussed the transferability of property. General rule, that is what properties can be transferred, what properties cannot be transferred. I hope this will help you for your examination purpose or for the knowledge purpose. So if you like this video, please like it, share it with your friends, and do not forget to subscribe my channel. Thank you friends.